Hello everybody, and thank you for joining us for today's webinar looking at sexual harassment in the workplace on a global basis. As I think probably most of you are aware, sexual harassment has become a real key hot topic with both legislators and regulators around the world. And so we thought it would be great to kick off our first webinar of our Global Board series this year, looking at some of the legal and regulatory landscape in key jurisdictions around the world, including kind of trends, challenges and key points for global companies when dealing with sexual harassment. I'm delighted today to be joined by a very experienced and excellent team. I have Bryn Doyle, who's a partner in our Manchester office, who is going to look at things from a UK and some of the European, continental Europe perspective. We have Kim Hodge, who is a partner in our Perth office in Australia, and Kim is going to give us the Australian perspective, and they have been doing a lot in this area, so it's really interesting, particularly for those in the UK, to hear what's been going on in Australia. Not to give any spoilers. Catherine Lau joins us from our New York office to give a US perspective, and Julia Yo is joining us from our Singapore office, who is going to give us an Asia Pacific perspective on these issues. Just a quick housekeeping point. All of you participating are on listen only mode. If you do have a question, then please pop it in the Q&A box, which should be down on the right hand bottom of your screen. If you mark it to come to all panelists, we have got a lot to get through today, but if we can, we will get to those questions and I'll put those to the panelists on your behalf. So without further ado, let me kick off, and it'd be great actually if each of you would be able to give me a high-level overview of the legal and regulatory landscape in each of your jurisdictions and any recent or forthcoming developments that the audience may be needing to know. So perhaps I could start with you, Bryn.
Thanks, Alison. Good afternoon, everyone. I hope you're all well. What's been particularly interesting for me over the course of the last sort of 6 to 12 months is I've been doing an awful lot of training and advisory for clients in this particular space, and it is very clear that across continental Europe, it is certainly sexual harassment, and the prevention of sexual harassment is certainly something that increasingly governments are taking more and more seriously, I think it's fair to say. From a UK perspective, hopefully most people on the call will be aware that there will be later on this year some new legislation coming in which effectively is going to make it a mandatory requirement for employers to take reasonable steps to prevent sexual harassment in the workplace. Now, you might say, well, under the existing legislation in the United Kingdom, at least, there is already prevention of sexual harassment, and that's true. But I think what this new legislation is going to do is going to place a greater emphasis on employers to kind of do that whole prevention piece. So personally, and it's difficult to know exactly where we're standing at the moment, but I think that there will definitely be more of an interpretation from the court system and the employment tribunal system in the UK, where it says, look, okay, fine, it is no longer just good enough just to do a bit of training on sexual harassment, tick a box effectively to say we've done that training and therefore that's it. This person did this really stupid thing, and we as the employer can't possibly be at fault for that because, you know, we've trained everybody on it. I think it's going to go more than that. For me, it's going to be about culture. It's going to be about setting the trend. It's going to be about leaders leading from the front, the kind of the tone from the top, certainly from the UK perspective. And unfortunately for employers, the larger the employer with the greater resource, and also probably with the more sophisticated HR administrative support that they have, I suspect that there'll be a greater emphasis on those employers as well to actually do something to prevent sexual harassment in the workplace. So it's going to be an interesting 6, 12, 18 months to see how the court interprets that in the UK, or the employment tribunal in the UK interprets that new landscape, the new legislation, and almost differentiates itself from what's already there, because the law already prevents or is intended to try to prevent sexual harassment in the workplace. So that's going to be interesting. Just from a continental Europe perspective, what's really struck me also, having done a number of training sessions just recently over the last few months or so, is the similarity in continental Europe to the United Kingdom position as well. So there isn't necessarily set legislation specifically preventing sexual harassment, although there is in some jurisdictions, but not everywhere. But what I think is interesting about that is that there is definitely a move of the local courts, the courts in those different continental European countries, to almost kind of make it so that employers are responsible for sexual harassment and moving it away from the responsibility of the individual. So this is just somebody who's gone and done something really bad on their own. It's your own fault, that individual person, to be more about this is about the company. And again, that feeds into that culture point about, for me, about making sure that as an industry, as a business, as a society, we are tackling this. We're making sure that we are addressing it adequately, taking it seriously, and doing something about it. So it's only going in one direction for me, in the United Kingdom and in the rest of continental Europe, and that is a good thing in that it is trying to stop sexual harassment from happening. Personally, I don't necessarily think that there is any more sexual harassment taking place. I think it's just that people are kind of more aware of it. People are more aware of their rights. People are more aware of when something actually that they might have put up with in the past is wrong. And so they're kind of going, do you know what, that isn't right. And I might have put up with it a year ago or 5 years ago, but I'm not going to now. So I think that's kind of the position. So it'll be interesting to see where that goes.
Thanks, Bryn, and I agree with you. I'm not sure there is any more, but certainly what's tolerated now compared to what used to be the case is very different. You only need to look at some of the kind of TV shows to see the difference of, you know, some things haven't aged very well from that perspective. But Kim, can I come to you now, because I know there is a new duty to prevent sexual harassment as well in Australia, and I think there's been a bit more of a focus around the health and safety side of it in Australia. So could you just talk us through that?
Absolutely, Alison. You're exactly right. We've really taken the concepts that have applied for many years in health and safety in Australia and probably throughout the world about eliminating those hazards and controlling the risks, and they've effectively applied that to sexual harassment, sexual discrimination. So they've amended the Sex Discrimination Act, to now include a positive duty. And it's not just on employers, they're using safety terminology as well around people that are controlling a business or an undertaking to take reasonable and proportionate measures to eliminate workplace sexual harassment and discrimination. So it's really interesting because people go, wow, how do you actually stop that? It's reasonable and proportionate measures. So it's going to be different depending on the size of the employer, what resources they have, the practicality and cost. But this really started from the resources sector in Australia, having a very poor record of harassment of females, and it's culminated in a whole Respect at Work movement, which has resulted in this change of legislation. And it's the fundamental change to really move from being reactive to very proactive. And that's the biggest change for employers, is to get their head around the fact that they have to prevent this. And the Human Rights Commission has come up with 7 standards around what they expect employers to do in that space to effectively eliminate or at least minimise the prospects of any sexual harassment occurring. So I won't go into those now, we might talk about them later, but it's about a 100-page booklet that the Commission has put out around guidance on this. So there really is quite a lot of information out there for employers in Australia on what is expected. And so if you are prosecuted, this regulator is saying, well, here's the guidance that we've issued you all. What parts of that are you following and what have you taken on board? So it's very interesting times, busy times for boards and executives to get up to speed with all this in Australia, Alison.
It certainly sounds like, and it's really interesting that it's such a similar position to where the UK are, but slightly further ahead. It sounds as though your guidance is a little bit longer than we have. Catherine, if I could come to you now for a US perspective, what's kind of the latest position in the US? I know there's been kind of legislation in the past, but kind of where are things at the moment?
Sure. Employment laws and specifically sexual harassment laws in the US are governed by both federal and state laws. So some states have more strict requirements in terms of what's required, the definition of sexual harassment. Consistent with what Bryn and Kim said, there is more scrutiny on sexual harassment allegations in the workplace. In fact, the Equal Employment Opportunity Commission, the federal agency, just issued 189-page guidance on harassment in the workplace. And this is the first time it's updated its guidance in 25 years. So it clarifies that sex discrimination and sex harassment need not be sexual in nature, and it need only be based on sex. And that includes, at the federal level, sexual orientation and gender identity, which captures the US Supreme Court decision in 2020, Bostock versus Clayton County. So that is a big move on behalf of the federal agency. And it clarifies when an employer has an obligation to conduct an investigation. So I think that's, we'll talk a little bit about that later, but in the US, that's one of the challenges for employers, not only, providing training and prohibiting sexual harassment with respect to policies and practices, but if and when a complaint arises, being able to identify the complaint and determine when an investigation needs to be done. So in terms of the landscape in the US, at a high level, not too different from what Bryn and Kim have shared, in the sense that federal and state laws continue to be refined to protect employees against sexual harassment.
That's really helpful. Thanks, Catherine. And last but not least, coming to you, Julia, going to give you the difficult task of, can you summarise the whole of Asia Pac for, and if you could do that in the kind of 5 minutes, that'd be great. But I think there's been some changes, particularly in China, around this. So it would be great to hear what kind of the mood is in Asia at the moment.
Sure. Thanks, Alison. So I think it's interesting as I hear the rest speak about what's happening in their jurisdiction, that the trend in Asia reflects that as well. We see a number of APEC countries now moving towards establishing special prohibitions on sexual harassment. But of course, first of all, there are already existing laws in most countries on sexual harassment, but most of them are embedded within an employment legislation, or perhaps the penal code, the criminal code. But now we are seeing specific laws being enacted, I think reflecting a recognition that this is a really serious affair. So first off, we have China. China in 2023 implemented a new law on protection of women's rights and interests. So not surprising, they have required mandatory measures by employers to establish a safe workplace, appoint designated personnel to investigate. But I think what's interesting is that the corrective measures that the authorities now are empowered to do, to order the employer to take action. They can even order administrative penalties on the officers of the company if the employer fails to comply with their orders. Additionally, we have victims that can file police reports, or they can file a civil suit against the harasser, and employers are obliged to actually assist the employees to defend their rights here. So in addition, the law also enables state agencies to even file public interest lawsuits against employers who consistently fail to implement proper measures to prevent and to address sexual harassment in the workplace. Similarly, in Taiwan, in 2024, we are seeing the coming to force of amendments to their Act on Gender Equality in Employment. I think, again, what is interesting is that they have increased punitive damages to 5 times of damages against the perpetrator if the person is actually a person in charge or the employer. And quite like India POSH Act, employers here are now obliged to notify local authorities and also inform them of the outcome of sexual harassment investigations. Victim may file a complaint to the local authorities. They may also actually file a complaint within 1 year of their resignation. So the length of time, the statute of limitation, is pretty long for them. And in some cases, they're even given up to 10 years from the conclusion of the sexual harassment to file a claim. In Japan, we also see a new law called the Comprehensive Labor Policy Promotion Act. That was passed in 2020, but is coming into effect quite recently in 2022 and will take full effect as the time goes. In this case, there are reputational risks for companies if they fail to comply with the law, because their names can be published, name and shame, although there's no criminal punishment for corporations or individuals. So if I can take a bit more time, so if we move to Southeast Asia, similarly, we see that in Indonesia and Malaysia, they have both enacted anti-sexual harassment law in 2022. Again, what is unique, or maybe what is worthy of highlighting, is that in both cases, employers will have to establish task force to deal with the incidents of workplace sexual harassment. And in Malaysia, they have established a specific 3-member tribunal to deal with such complaints. And they can order the offender to issue an apology or even a public apology if the sexual harassment act takes place in public. Right? They can also order compensation to the offender up to 52,000 USD, right? For loss and damages suffered by the victim. So you will find that I guess the overall picture is that countries are placing an increased emphasis on preventive measures, right? Their deterrent effects, they're hoping will be stronger with all the penalties. They are wanting employers to implement anti-sexual harassment policy more significantly, and also to conduct training for employees. I think there is a growing focus on ensuring accessible and effective complaint mechanisms as well. So I think the development here in Asia does reflect the trend globally.
It certainly sounds that way, although it scares me a little bit when you say it's 10 years to bring a claim. I can barely remember what I did yesterday, let alone 10 years ago. So I should imagine that's really quite a challenge for employers to defend that position. Okay, we've looked at kind of on a global basis, and it does seem to be a trend that there's increased responsibility on employers to address sexual harassment. I know, Bryn, that over the last 12 to 18 months, I've barely seen you, because I think all that you do now is pretty much be training clients around. I have to be careful around sexual harassment. Like, to be very clear, it's not how to carry out sexual harassment, but rather the prevention of sexual harassment. And I think, you know, from our conversations, one of the things that's been really important is kind of setting that tone from the top and getting that part right in order to make those cultural changes. I just wondered if you could tell us a little bit kind of more about that and why that's important.
Yeah, sure. And it's really interesting because yeah, I've been in private practice for 20 years now, and so when I first started doing kind of harassment and anti-harassment type of work, it was very much seen as a almost a necessary evil for training. Oh, okay, we've just got to do this because it's something that we've got to do. We don't really take it seriously, and probably for 15 years of those 20, that was the position. And then probably in the last 5 years, and maybe it's a consequence of Me Too, something like that, we've definitely seen a move towards actually, we probably do need to take this seriously, and not just say we're going to take it seriously. It fits into so many different things. So, you know, the rise of the ESG agenda is huge. I'm sure every single person on this call has seen and heard of that rise, and it fits squarely into that as well. It fits into this whole thing about culture and effectively being seen to be doing the right thing. And for me in particular, where I've had the best results in terms of getting people on board with this, it tends to have been at the very senior level, so C-suite, your exec level teams, and in particular coming at this not from a stick, but coming at it from a carrot. So to give you one example, we've done some training for client relatively recently, and it was very clear that their internal HR, internal legal and risk teams were very keen for us to try to change the culture, not because the culture was bad in any way, but just because actually we want to be seen to be taking this seriously. But the best way, and really the only way that you can do that, is right from the very top. So it's the tone from the top, the exec, the C-suite taking this seriously. And so we went in and we did quite a lot of training with them, made them understand why it was important. And rather than say it's important because if you don't get it right, you're going to get sued, you're going to be personally responsible, there's going to be all of those other elements of it. Actually, flip it around and do it from a positive perspective. So say, actually, do you know what? If you're in a business, in an industry that has a particular group of people that are underrepresented, why don't we use this to our advantage? Why don't we say, okay, fine, we are going to go out and we're going to say we're going to create a workplace culture which is really inclusive, which people can come to and feel totally safe, not feel like they're going to be sneered at or looked at or propositioned or anything like that. And that's both sexes, by the way. It doesn't matter. If you can create that culture, then you can then take that to market and effectively say, look how great a place it is that we work. Look how good this place is that we work in. Come and work for us. Don't go work for our competitors. Come work for us, because you know what? You're going to progress really well here. And also you're not going to be exposed to some of the things that you might be doing. And I find it really interesting, going back to what Kim was saying before about, in particular in Australia, where there are certain industries, I think it's the mining industry there, that has been deemed to be, whether it does or not is a different matter, but it's been deemed to have a particular problem with sexual harassment. You're now starting to see that in the UK in certain areas. I'm looking at things like for the FCA now in regulated industry, in the financial industry, starting to go, okay, fine. Is there a problem here? What are we going to do? Can we try to address it? And I find it really, really interesting. So for me, it's about this tone from the top. It's about going, right, let's use this as an opportunity to demonstrate that we are a great place to work and to win all of this talent over from our competitors.
Thanks, Bryn. And you just mentioned there kind of Australia and the mining industry and the perceptions of that and what's happening. So coming to you, Kim, is kind of the way that Bryn's approaching the training and how we've seen it being approached in the UK, the way that it's being approached in Australia, is it a cultural thing? How's that kind of playing out in practice?
Look, very much. I think Bryn must have stolen my notes, because tone from the top is exactly from some of the materials that the Australian Human Rights Commission puts out. But I think just to touch on what Bryn was saying, 5 years ago, the mining sector did have a lot of sexual harassment cases. And how were they dealt with? Well, they're generally wrapped up and often with a non-disclosure agreement and a settlement payment, and people were, it was moved on and hidden. Non-disclosure agreements are still permitted, there's talk of changing all those, but the mining sector in itself is under a large degree of scrutiny, and in particular, this higher standard around an incident of either gendered violence or sexual harassment must be reported to the WorkSafe regulators. Certainly in Western Australia, it's now starting to occur in other states of Australia, but because of their poor industry standards, really, for some time, they've now been put on this very high level of requirement and compliance. So the government is now getting the statistics on the reports. But to go to Bryn's point, I mentioned 7 standards that are imposed. The first 3 of those deal with leadership, culture, and knowledge. And the leadership, it is exactly that tone from the top. And so I'm starting to talk to boards now who are saying, what's all this sexual harassment stuff? What do we need to do? And it's like, well, it's in your court. It's your responsibility to absolutely set that tone and the culture of your organisation and how you want it to run. And so they're very interesting discussions that are being had at the moment. The top tier sort of companies all get it, but it's slowly percolating down to other employers now.
Thanks, Kim. And Catherine, is it the same in the US? Is training approached in the same way? I think in New York, you've had it for some time now in terms of needing to do that training. And so how's that played out?
On the topic of training, I would say, in the US, Conceptually, employers have taken it pretty seriously for quite some time, in part because many states have required anti-harassment training for years now. California in particular, so I focus on California and New York, and especially in California where the potential risk exposure and liability is so high. I think conceptually, even at the top, they've taken it seriously. But more and more, the training has evolved to incorporate by necessity different aspects. And at the board level, as well as at the executive level, I think training really accomplishes, 3 different goals in terms of buckets. There's the legal piece where it's required in certain states or recommended in certain states, certainly, and obviously avoiding extensive exposure. But then the cultural piece that Bryn and Kim have mentioned, right? Changing the workplace, inclusion is, frankly, really beneficial from a cultural perspective for many employees, especially as new generations enter the workforce. But ultimately, even, the McKinsey reports have shown it's better business. It actually results in more profitability for most companies and significantly more. Right. And that makes sense. Nobody does their job or focuses on their responsibilities when they feel that they're being harassed or discriminated against based on sex. They're not like, let me go be my best self at work here, and when they have that additional hurdle. So training is, has been important for some time. Importantly, from a legal perspective, it also can be your first line of defense. So for example, in California, there's an affirmative duty to prevent harassment and discrimination. There's a separate cause of action that may be brought for an employer's failure to prevent harassment or discrimination. And what do courts look at? Whether there's training, whether there's a complaint procedure, whether there's a lawful policy, whether employees knew about the policy. And you can accomplish and hit all of those, tick all of those check boxes if you incorporate that into your training.
And I'm just staying with you, Catherine. I think one of the things that we've seen on a global basis as a team is around investigations. If I I've been practicing for only 1 or 2 years more than Bryn, and certainly over that time, what I've seen, probably particularly in the last 5 years, is that real increase in investigations. And historically, a lot of them would have been done in-house by the HR team, quite low key, dealing with the particular issue at hand. But what we're seeing and what we're being asked for by clients is either to do investigations for them or help them, support them around either them doing a lot more detailed investigations themselves or instructing, say, a barrister or a third party to do that investigation for them. So there seems to be some real differences and a change, and I think some of that comes from this legislation. So from your perspective, are there any particular challenges that you see companies coming up against, any particular practical tips when looking at investigations and how people deal with them?
Absolutely. I mean, investigations are being more scrutinized as well, including the investigator. So we are definitely seeing more requests for external investigations. Also, there's just added layers of complexity in the workplace, right? Virtual remote workers make a big difference when an investigation involves them. We have employees transferring either physically, to other jurisdictions over the course of their employment, just because travel is more frequent, or working for a period of time, whether it's a secondment or just a conference in a different jurisdiction. So, and you're working with people across, the pond, as you guys say, or around the world. So when an investigation is essentially global, that can be difficult for a local HR person to conduct. So we're getting a lot more requests for investigations, and then we're also doing a lot of trainings in terms of how to conduct global investigations, training the trainer. And we're incorporating, at least from a US perspective, all of the guidance in US case law, where courts are dinging employers for perhaps not a fair, thorough, or prompt investigation, which are the 3 requirements. And, depending on the size of the workforce, I think it's important to really analyze who the right person is to conduct the investigation and scope out the investigation in advance in terms of a plan, whether that's a verbal versus a written report at the end, how the witnesses are going to be interviewed. In the US, confidentiality is a serious concern for employees as well as employers, not necessarily over-promising. And then, also retaliation. I've seen so many investigations where the underlying conduct is not substantiated, but retaliation is, questionable once somebody finds out about the need for an investigation. And that's human nature oftentimes. If you're accused of some sort of wrongdoing that you feel is unjust, but you have to interact with this person who accused you on a day-to-day basis, it's hard to keep that under wraps. So all of these elements are critical in terms of an investigation.
I've certainly seen, in terms of the global investigations, concerns around transfer of data as well, kind of from a European perspective, the GDPR and how that data is being moved around, where that investigation is being global, and then also issues around privilege arising. But I completely agree with you around the confidentiality as well, and kind of a thoughts about how the individual who's made the complaints is treated. I've certainly seen much more around that, in terms of, I think, and I may be doing a disservice, and maybe it's only the cases I've seen, is those that have made the allegations were almost treated as the accused. They're the ones, it's kind of, let's prove what they're saying is wrong, rather than actually kind of being a lot more balanced about that investigation and being really understanding of how difficult it can be for them to raise those issues, and how it impacts them. But if I can come to you, Bryn, I mean, in terms of the UK, certainly we've seen a lot of increased investigations, and I know a lot of our continental European colleagues also spent a huge amount of that time doing investigations. Is there any particular observations or top tips that you can add?
Yeah, and it's interesting listening to Catherine. Obviously, Catherine and I work together quite closely on a number of things and have trained clients together, and it's very, very similar in the UK as it is the US. There is definitely much more of an emphasis on not necessarily the thoroughness of investigations, because I have to say, certainly the clients that I work with, actually most people do try to do a thorough investigation if they can. It tends to be more about the fairness of the investigation. So, allowing everybody to have a voice, allowing everybody to the opportunity to have their say. Kind of going to your point almost about our colleague David Winkup says bullies and harassers have rights too, is his phrase, and that's absolutely right. Not making assumptions or presumptions, addressing your own internal bias. I think sometimes there is often with an investigator that internal bias that, oh well, it must be right because blah blah blah, or whatever it might be, and so taking that step back, and I am definitely seeing a move towards, certainly in the employment tribunal in the UK, scenarios where the focus has become much more about the investigation itself rather than the allegation, if that makes sense. So the allegation itself may well be one particular thing, but quite often the tribunal are really interested in working out, okay, well, have they done enough? Has the investigator done enough? Have they asked the appropriate questions? Have they not asked certain questions? The point about anonymity and confidentiality. And then just to kind of expand on Catherine's point as well, the retaliatory point, as we would say here in the UK, victimisation, is again a really increasing thing. I'm definitely seeing cases where people who have either raised grievances, complaints, allegations, or have been witnesses and then themselves feel like they've been victimised or had retaliation against them, they are also increasingly aware of their rights and bringing claims too. So it's definitely a growing area. You asked me for a top tip. The top tip for investigations for me is to take a step back, is to have a think about, okay, I'm going to ask this question. Why am I asking that question? So not is there an ulterior motive, not is there a bias, implicit or otherwise. Why am I asking this question? Is it going to get me to the bottom of the situation that I'm investigating? And particularly when it becomes a sexual harassment, because it is so sensitive, rightly so, it is so charged in many respects, and so it's something that absolutely needs to be taken into consideration. And finally, finding the right person to do that investigation as well. Don't be afraid to kind of go, do you know what, actually they aren't the right person to do this investigation. They have great skills, they have a great skill set in finding out the truth or getting to the bottom of a particular situation, but actually, is there a danger that in doing so, that could impact upon the potential victim or even the potential alleged harasser as well? So kind of taking some of those things into consideration is important.
Thanks, Bryn. I completely agree in terms of that step back, because it's easy to kind of go charging in and rather than looking at the bigger picture of what needs to be done. Julia, if I could come to you, and is the position the same in Asia? I know you get involved in investigations, but is the approach similar to the US and in Europe?
I think definitely doing a comprehensive investigation is really important. But I think let's talk about the Asia society, right? I think we all know that it's a more conservative, reticent kind of society. So I think one of the key challenges in doing an investigation is empowering the victims and the bystanders who witness the harassment to actually speak up. We often have victims who complain and then retract the complaints because they do not want to go through the investigation. Because we live in a culture, right, where maintaining peace is very important, not being a troublemaker. So I think encouraging them to continue with their complaint, changing mindsets that it is fine to actually complain and to want to see behavior that is inappropriate to be changed, right? Creating the safe space for them to come forward. So how do we do this, right? I think what is important is also prompt investigation, having a clear and transparent process, and also making it clear that that there is the same treatment for all violators. So no one is accorded any special treatment. I think particularly in Asia, we see this issue of power harassment, the vertical relationship, right? The harasser is the person in charge. Like in Taiwan, they are enacting laws on this, right? The perpetrator is somebody who is in charge, who is able to influence the outcome of your employment or how your employment will progress within the company. So I think that the laws are taking this very seriously. So we want to take note of this in an Asian investigation. To me, I think one of the success factor in having a good investigation is to give time to the victim to speak up. So you cannot rush the victim sometimes, right? You got to give them time to think about it, to answer difficult questions like why did you hold on to the complaints for such a long time without coming forward? Perhaps it's also about giving them comfort in terms of giving their evidence in a local language. So, local investigators or external investigators, we tend to speak in English, but it may be important to bring somebody on board who is able to speak in the local language and therefore give some confidence and support for the victim to speak up. So I think that's particularly for Asia, in my view. The investigations, I think also about maintaining confidentiality and ensuring that no retaliation is an equally key point. And in terms of retaliation, I wanted to say that the minute a complaint is raised, is very important for the HR, the supervisors to monitor for retaliatory action, and also post-investigation, that the complaint may not be made out or the complaint has actually been made out, but that retaliation can continue to take place against the victim. So this is where you want to watch out for, because otherwise then the whole process becomes, you actually negate the whole process after disciplinary action, but the victim find that they are also penalized in the process.
Thank you. And if I can stay with you, Julia, and kind of one of the things coming out of this, and something we get asked a lot of questions about, is, so we hear that it's good to have a policy in place and we need to train people on that policy and obviously follow that policy and live and breathe it. But for many global clients, what they're really interested in is, can we have one policy that goes across the world? Does that work? Or do you think when it comes to a kind of a sexual harassment policy that you need to have a different policy for each of your jurisdictions? How best do you think employers could tackle that?
Yeah, I think there's certainly a lot of advantages in having a single global policy. I mean, there's consistency, right? So there is a clear, consistent message that goes to all the location and offices that what the company regards or what the group regards as sexual harassment, and also your value and your zero tolerance for any such incidents. There is also branding, of course. You know, you reinforces your global brand image when you have a single policy. And of course, it's efficient to just have a policy that runs across all jurisdiction. But equally, I think we note that a lot of global companies find challenges in doing this because local compliance, right? I ran through the Asia Pac laws. They have a slightly different take on, you know, what are the employer's obligation, what is the threshold that will fall within, you know, a punishable acts. So I think there's also a lot of confusion, I think, for employees when you run into, let's say, local compliance and coming up with local policies. But I think definitely there is a space for this because you also need to be culturally sensitive and adaptable, right? Whatever is acceptable in a Western society may not be so in Asia. And also Asia will have its own type of peculiar harassment issues. Right, it can be, you know, harassment on due to the way a drinking culture is developed within the company, or the way, you know, how women should dress and how we should speak to ladies, etc. So I think what most companies, global companies, are trying to seek a middle ground. They go for a hybrid position, i.e. we have, let's say, a global framework that kind of establishes the core principles of what the company is looking for in terms of sexual harassment or appropriate behavior. But at the same time, they will have local adaptation to ensure compliance and sensitivity. So how you do it is probably you have local handbooks as well that complements the global policy, and you know that kind of run through what are the specific local compliance that you need, such as the process that's being put forward. For example, in India, you have a very specific act, POSH Act, the Prevention of Sexual Harassment Act, which dictates how an investigation is supposed to be held, investigated. So you do need to run through that portion in order to comply with the law. You need to put in my view, specific examples that's very that's really adaptable and that's very specific for your culture in order for you to train the employees, right? And there's no point referring to a Western example and then it doesn't have its application in the local regime. But communication at the end of the day, whatever policies that you have is really important. The company employees must know exactly what the company stands for and what is not acceptable. And lastly, I would say this, you know, it's very important to maintain and review your policies, whether it's single or whether it's local policies. You will have your experience with the various type of cases that comes out, and then there's no sacred cow. You should adapt, you should amend. You know, if you see that the policy is just not working, is not effective, is not reaching out to the employees and empowering them to come forward with their sexual harassment complaints or changing the toxic work culture. So I think that's my take for Asia.
Okay, that's really helpful, thank you. And I suppose just staying on policies for 1 minute, Bryn, just in terms of the new duties in the UK, I know that certainly the questions I've been getting from clients is, do we need a standalone sexual harassment policy, or does our kind of anti-harassment, our general policy that says don't harass on any grounds, enough? What's your view on that?
Classic lawyer's answer, it depends, I think. So I don't have a particularly strong view either way, if I'm honest with you. I think as long as the policy is sufficiently clear that it is addressing sexual harassment as a standalone area of harassment, I don't think you necessarily have to have a separate sexual harassment or anti-sex harassment policy. Although I do have some clients who have got them. Personally, I think the importance is more about, as Julie was just saying, the kind of the setting out what is and isn't, perhaps more importantly, isn't acceptable in terms of the behaviours. I'm a big believer, in particular, in any training that I give, and if anyone's had training from me in the past, they'll know I keep banging on about different examples and cases and all of those sorts of things that I do. But I think it really helps people to understand what is and isn't acceptable. And actually, it's one of Catherine's examples, which I always refer back to, which she told me about from one of her cases, where in paper, sorry, Catherine, I'm going to steal this from you, but in paper, someone says, when you read it down, it says nice dress, right? So the words that were said by one employee to another person is nice dress, and you read it and think, well, is that bad? But it's the way in which it said it, and so Catherine gives the example, it's nice dress, and so the intonation, the way in which it's said, is the element that creates the sexual harassment in that particular case, certainly from a UK perspective. And so how do you get that across to people in a document, in a piece of paper? And so I think it's by giving examples, it's by talking about it, it's about doing the training as well, in conjunction with the policy, to allow people to understand what is, and perhaps more importantly what isn't acceptable. That's where I go to. So rather than having, oh, you should or you shouldn't have one, again, I'm not too concerned about it, but what I am really concerned about is making sure that the policy itself is very clear in terms of what us as a business deems to be acts of sexual harassment, and this is why we will take it very seriously if you cross that line.
Yeah, no, I certainly agree with you that kind of the context is everything in these in these situations, and you can look at things and think, well, that's not that bad, and then you understand the context or who said and everything else, and it completely changes the perspective. Kim, is it just in terms of, given you've got your 100 pages of guidance, is it the same in Australia, that does it need to be a standalone policy, or can it be part of a broader policy?
There's no set rule, Alison. It's interesting though, because it's a change of mindset in that this is a very safety focused approach. So it's like a risk in the workplace. You don't want someone to trip over something or hurt themselves. It's a risk management approach. You're identifying risks, you're assessing those risks, what control measures can be put in place for that, and then looking at those control measures. So in some ways, because of that positive duty to prevent it, it may be better in a standalone policy. But there is no right or wrong answer there. But it's just interesting around, this is a all-encompassing program where we're looking at equally, we touched on it earlier, around even support. What support have you got for people reporting these incidents, and what is the reporting mechanism, and how inclusive is that, how widespread is that? And so it's a very different approach. It's highly safety focused, and so for any practitioners with a bit of background in safety, you'll find a lot of comfort in the Australian system and all those hundreds of pages of guidance materials, because they treat it as something that is going to happen, and so therefore you have to prevent it and minimise it. So to answer your question, Alison, I would probably be recommending it in a standalone policy, but there's no requirement on that in the legislation.
Yeah, I love your comment that, you've got to assume it's going to happen. It's just about that prevention, mitigation. But I think you're probably right. Human nature. I'm just going to pick up on one of the questions that we've had in the Q&A at this point, because it is talking about policy, and perhaps I can come to Bryn and Catherine on this, because I'm interested in the kind of different opinions on this across the two jurisdictions. But do you think that having a policy in the workplace that addresses personal relationships at work is a good thing as part of to help the control measures around this? So if I could come to you, Bryn, first, in terms of what's your view on personal relationships at work? And I might have to say, given that you married somebody at work, but anyway.
Yes, yeah, okay, that's fine. We didn't meet at work, I should find that out, but there you go. I personally don't particularly like having such a prescriptive rule that says you can't have relationships at work. I know that we have some clients that do, and there are certain circumstances where I think it's appropriate to have a line to be drawn, where you've got somebody with managerial responsibility, particularly if that relates to their salary and those sorts of things. I think having some kind of form of rule that applies there, so that there's some transparency to avoid almost allegations of kind of bias, that helps everybody in those scenarios. But I'm not a massive fan of a prescriptive rule that says you must not do. The way I like to do everything in life is to encourage people to do things rather than. So I'm more a carrot guy than a stick guy, to be honest with you. So I would prefer for people to be more encouraged to be transparent in terms of their relationship situation at work. But I do get that there will be circumstances where it might be appropriate to do it. My personal view is that I wouldn't be so prescriptive. I've got 3 kids, and so therefore, if I tell my children not to do something, then the first thing that they're thinking is, how can I do this? And it feels a little bit like that sometimes to me. So I'm kind of thinking, right, okay, well, let's find a way in which we can achieve the same thing that we're trying to achieve here, which is avoiding situations at work, avoiding scenarios where somebody might be accused of some kind of bias, that sort of stuff, but by not being too prescriptive. That's my personal view anyway.
Yeah, thank you for that. And Catherine, is your view the same? Is it the same in the US?
Not exactly. I would say that, personal relationship policies should accurately reflect what the company is willing to do, right? And oftentimes it's not so much a personal relationship policy, but is it a conflict of interest? And I think that is something that can be incorporated into our conflict of interest policy. Also, there's a lot of companies, especially post Me Too, that reinitiated the love contract, if you will, where you have to disclose a relationship. Now, query as an employer what you're actually going to do with that information. If somebody does not disclose, what exactly are you going to do in terms of discipline, if anything at all? So ensuring that you have a policy that's reflective of what you're planning on doing, whether or not you administratively can handle that, is key, I think, before you decide whether or not you're going to have such a policy, right? And I think a nice, consistent policy I've seen is to ensure that there's no direct or indirect supervision with respect to people who have personal relationships. And this could be romantic relationships, sibling relationships or familial relationships, et cetera, to avoid that type of conflict. Again, though, you actually have to enforce it.
Yeah.
Right. Sorry, go ahead, Allison.
No, go, no, you go.
Oh, no. And, I just wanted to address 2 other questions you had before with respect to policy. In terms of a single anti-harassment policy, even in the US, that can be problematic because there are specific requirements depending on the state that needs to be incorporated in your policy. So I just wanted to echo Julia's sentiment of core principles, yes, the tone, yes, general examples of what constitutes harassment, yes, include that in there. But then in terms of, for example, New York and California, you have to direct employees to the administrative agencies. There's very detailed specifics regarding the complaint procedure, so it might be worth having addendum for certain states. And then does there need to be a standalone sexual harassment policy as a general rule in the US? Yes, we would recommend that. So calling out sexual harassment in particular, and providing those types of examples supplemented by training. Brandon noted the nice dress example. Add on top of that, because this was an actual case, excessive lip licking while you're saying nice dress in a creepy tone. That adds a whole new element to me coming into the office and saying, "Hi, Allison, nice dress. Where'd you get that?"
Yeah, no, absolutely. And just touching on the relationship policy, I know I drafted one once, and when it comes to a relationship, it's kind of how do you define that, particularly where it may be a not necessarily a sexual relationship, but that kind of relationship is, when is a relationship and when is it not? And is it first date?
Yeah, when do you disclose? After you meet the parents, before you meet the parents? And I actually did an investigation where I thought I was talking to a wall because I kept on referencing a relationship, and there was in fact a sexual relationship. But at one point, the gentleman said, "We weren't in a relationship, we weren't steady." And I said, "Oh gosh, okay, I don't mean that it was your girlfriend or boyfriend.
Yeah.
Just having sexual interactions is a relationship." And literally, this is a manager was like, "Oh, yeah, I think I did have a relationship. Yes, I believe so."
Well, exactly. It's, as I say, I've had some fun trying to draft that in the past. So if I could just come to you, Kim, in terms of I'm conscious we're kind of getting close to the end of time, the time that we have. Have you got, say, 3 practical tips of what employers could be doing at this stage in terms of the sexual harassment in the workplace?
I have, Alison, but it's probably fairly specific for Australia. But and we've touched on it, I think, broadly throughout the discussion today. But proactive leadership is critical. It has to come from the top, as Bryn said. It requires support, it requires presence, and it requires this leadership from the top. So I think boards and executives need to be proactive in this space. The second is, I think that organisations need to develop a vision of what a safe, respectful and inclusive workplace looks like. Bearing in mind that could be different. It's probably different to the mining sector to another sector, but you need a vision, and that needs to be communicated, and expectations need to be set about that vision, and the support that's required to make that vision part of the culture. And I think third and finally, I would encourage organisations to monitor, review and assess their progress, and actively seek feedback, good and bad feedback, and look at your controls that you've put in place and see if they're working or not being used or no one knows about them. Yeah, monitor, review and assess. That would be the 3 takeaways for Australia.
Okay, thank you. I'm very conscious of the time. We've got a number of questions. I'm going to pick one of them, and then after the webinar, we'll follow up on in terms of the other ones of them. But if I can quickly go round the group, and I've picked this one because I know it's one that comes up regularly. But if you have an allegation of sexual harassment which may cross into the criminal threshold, are you under an obligation to report it to the police? And if you do report it to police and they investigate, how does that impact on your internal investigation? If I come to you, Bryn, first, is that okay?
Yeah, sure, no problem. And you're right, it's something that comes up quite regularly. Certainly in the United Kingdom, there's no strict obligation. There might be some requirements if you're in a regulated industry, where there are some requirements to proactively report. But there's no strict requirement from a criminal perspective to report that to the police. Albeit many employers do, and many employers feel it's the right thing to do as well. It is without question, though, difficult, because as soon as you report that to the police or relevant law enforcement authority, it is going to impact upon your own investigation. But that's not to say that you shouldn't do it, but it will do. As a general rule, what I tend to say to clients is do as much as you can quickly as possible. But if you feel like you need to report it, then report it. That's kind of my position in the UK.
Okay, Julia?
I think it's a difficult situation, but for example, I touch on Taiwan's laws, right? So there is a positive obligation to actually report to the local authorities and also to file an outcome report, as well as to assist a victim when they want to file a police report. So I think depending on the laws of each country, there may be a positive obligation for the company to assist at least the victim to file that report. So, but I agree with Bryn, right? I mean, you filing the report is just one piece of the story. So within the company, there should still be steps taken to investigate what's the position for the company, and I think it's also a judgment call, and to speak also and advise the victim, of the consequences of course, going through the criminal report, the kind of, the difficulty that comes along with filing a police report. But I'm actually for it. I think whenever there is an element of criminality in the conduct, I think the company should actually file the report. I think it's important for reputational issues and also in terms of protecting the wider employee in the workforce.
Okay, right, 30 seconds each. Catherine, go.
Generally in the US, there is no such obligation or requirement. Now, what we recommend is strongly encouraging anybody who's been subjected to criminal behavior to report it themselves. But generally speaking, I actually have not worked with clients that have reported it as the employer.
Okay, thank you. And Kim?
In the mining sector, Alison, there is a requirement to report that to the regulator, who may then involve the police. But in our general society, it's normally up to the victim to notify police. And then if that is to occur, then obviously your own internal investigation has to take a back seat until the police have completed what they need to complete. So, but no strict requirement on the employer other than in the mining sector.
Brilliant. Okay.
I should add that in the US, you still have an obligation to conduct an investigation. Obviously, you don't want to interfere with the police investigation, but as you may know, that police investigations can be quite lengthy and may not be as prompt as an employer's.
Yeah, absolutely. Right, we've just hit the 2 o'clock mark for those of you who are in the UK. Thank you so much to the panel today for all of your input. Thank you particularly to Kim and to Julia for staying up late to do the webinar today. Thank you everybody for joining us, and thank you for the questions. As I say, we will come back on those questions that we haven't had a chance to answer, but it was our pleasure having you with us, and I hope you found it useful. Have a good rest of your day. Thank you very much.
Thanks.